In these original proceedings, we consider an issue of first impression arising from elder abuse litigation, whether the statute of limitations applicable to a civil action for damages against a health care provider convicted of felony elder abuse is Code of Civil Procedure Section 340.5, which provides a maximum 3-year limitations period for medical malpractice actions, or Code of Civil Procedure Section 340.3, which provides a limitations period of at least 1 year after the judgment of conviction for an action based on the defendant's commission of a felony offense. After petitioner guardian pleaded no contest to 6 counts of felony abuse of patients, 3 actions for damages were filed against guardian. The complaints allege that guardian was convicted of violating Penal Law Section 368 by willfully injuring or endangering plaintiff's deceased parents while they were patients in guardian's skilled nursing facility. Guardian contended in the demurrer in the complaints that the actions are time barred by Section 340.5 because the actions were not filed within the 3-year limitations period for medical malpractice. The trial court agreed with plaintiffs that their actions were timely filed under Section 340.3 within 1 year of guardian's convictions for felony elder abuse, and overruled guardian's demurrers on the ground. Because we conclude that Section 340.3 is the applicable statute of limitations, and therefore the demurrers were properly overruled, we will deny the petitions for extraordinary relief from the trial court's action. The guardian filed a demurrer in response to each of the 3 complaints filed after guardian's convictions for felony elder abuse. When its demurrers were overruled, guardian petitioned this court in each case for a writ of mandate directing respondent court to vacate its order and to enter a new order sustaining the demurrer without leave to amend. We summarily denied the 3 motions. Guardian then petitioned for review by the California Supreme Court, which granted review as to each petition and ordered this court to vacate its order denying mandate and to issue an order directing respondent court to show cause why the relief sought in the petition should not be granted. We have complied with the California Supreme Court's order. Additionally, because the writ petitions raise the same statute of limitations motion, we ordered that those original proceedings be consolidated for purposes of the order to show cause, briefing, oral argument, and decision. We also issued a temporary stay of all trial court proceedings while our review was pending and granted the application of the California Association of Health Facilities to file an amicus curiae brief in support of petitioner. Our review begins with a summary of the factual and procedural background of each case, guardian's demurrers, and the trial court's orders. Real party interest Arlene Myers is the daughter of Hazel Sharp, a former patient at a skilled nursing facility, guardian of Los Gatos, which was owned and operated by Guardian. On June 22, 2000, plaintiff filed a complaint against defendants Guardian, Guardian Service Incorporated, and guardian of Los Gatos, on behalf of her mother and herself as guardian ad litem. After Skagg died, plaintiff filed a first amended complaint as successor in interest and administrator of Skagg's estate.